told if she was approved it. Or is it who? Well, it's for the retired. One is to be printed forward. The other is a HDMI and the key large files. But I didn't put in a room number or anything. I might just have to wait and see. Yeah. But so yours went to the room. Yeah. Oh, I see. Okay. Fine. Is court ready?
Yeah.
Only because I ordered a through. Oh. But, it says property of the NR, court 71. Well, live streaming is on.
Streaming is on.
So that's a step in the right direction. I'm very grateful to everyone that's scurried around to move courts over the shorter term. I suspect is addressed mainly to the juniors, so thank you.
Correct. Just a few more points if I may, my lady.
Yes.
I have said that the mother's case until closing was that these properties should be provided when children are adults for a combination of two reasons: past conduct and parity with A. In terms of the second of those first, just wanted to point your Ladyship and your Lordships to something that the learned judge said in his judgment. It's a core 115. And it's where he goes through the chronology that parties have prepared and makes his findings, and his contribution is in bold, as it were. And just reading down from the top, you'll see he says he's a man of excellent memory, curious that she should get a date wrong, particularly his current case when relocation commenced very shortly after Kay's princess was born. The evidence suggests that the father is capable of spontaneous and extraordinarily generous gestures. This is in particular illustrated by his purchase of a flat for A. It is also supported by mum's evidence of purchase of a valuable ring. We say quite simply, buying a flat for a then just adult child, I think, but any child, can't both be a extraordinarily generous gesture and at the same time an obligation to all children alike, any of the others, or particularly an obligation that the court should be imposing on a father, and again particularly years ahead of when it's to happen. In terms of conduct, your Lordship obviously knows this. Conduct isn't mentioned in Schedule 1. It's one of the factors that does appear in the Matrimonial Causes Act, but doesn't appear in Schedule 1. And I say factors, it's not quite how the Law Commission saw them, certainly in 1983. in the authorities file, at 329. Under guidelines for the exercise of the court's discretion, if your lordship has that.
Yes, thank you.
Sorry, I'm behind. Can you?
Sorry, authorities 329.
Thank you.
Where they record that the Affiliation Proceedings Act contain no guidelines. No doubt it's unnecessary because the maximum available was £1.50 a week. Domestic Proceedings Management Courts Act 1978 extended the court's powers of affiliation proceedings and also laid down specific guidelines. And I just draw attention to the word guidelines. Because that's how the Law Commission saw these. They were guidelines. They weren't one of many things that the court might want to look at. They were the guidelines.
Well, except we do have all the circumstances.
Oh, can I take your look, your ladyship?
Yes.
Down to the bottom of the page.
Down.
Down to the bottom of the page, if you would, my lady. These guidelines were introduced into the guardianship legislation as recently as 1978, and we see no reason to recommend a change in any of them. A change in them. They have the advantage of flexibility and the direction of the court to have regard to all the circumstances, including the financial obligations of the parents, would seem to be particularly appropriate in the case of late claims against fathers of non-marital children. They saw them as the steer, and at least in this instance, late claims against fathers of non-marital children as limiting what the court might do, not expanding it. Of course, conduct as a factor or guideline upon which the court positively acts is vanishingly rare now. In matrimonial cases, I've made the point about O&P and that even in the most egregious, imaginable case of conduct, there was no capital provision, although there was capital to do it, but there was. But we say what the mother invited the court to do in this case was to elevate conduct, equality with A, welfare, above the guidelines, and guidelines they're intended to be, set out in the Act, and above the policy of the Act that I've already made submissions about. Now, I suppose it could be said that the judge in this case did something slightly different, in that he extrapolated from conduct of vulnerability as adults. But for the reasons I've given, we say that was that is A, irrelevant because they'll be adults, and B, not evidence. And as adults, their welfare is not the court's concern because that is for children. But more particularly, as my learned friend submits in his skeleton, the judge effectively took judicial notice of the effect of this sort of conduct on people growing up. We submit that you can't take judicial notice of the psychological state and vulnerabilities of adults in 7-8 years' time. And even if you were thinking about doing it, you'd need evidence of that, obviously, but you'd also want, wouldn't you, evidence of what effect the making of such an order might have. But assuming K, for instance, as the later Kafkas report says, the reference is at C, core 230, and I don't think you literally needs to turn it up now, but it's one paragraph in the middle of the page. is resilient, shows no likelihood of developing depression, is clear that she doesn't want to see her father, what will be the effect of ordering her father to give her a huge sum of money for a home in 7-8 years' time, potentially longer? One simply doesn't know, and it wasn't considered. Would it mean that they felt under pressure to assist their mother? Would that be good for them? This is, of course, all welfare, and as I've submitted, welfare of adults is not a relevant consideration. But none of this was in evidence, none of it was considered. And what we submit the judge plainly did was allow conduct, past conduct, to take centre stage when that is not something you should have allowed to do. And in doing so, lost sight of the limited parameters of Schedule 1 fruition for adults. But doing that, he also, and you'll have heard this argument in many other cases, invited the same sort of search for conduct that might affect children in later life in every other case, in a lot of other cases. The courts having effectively put to bed in all but name the relevance of conduct in matrimonial proceedings, is it really going to now invite submissions in Schedule 1 cases that it is relevant? And where is that going to leave fathers who can now, if this is right, no longer be told, as they are, whatever you do have to provide in capital terms comes back to you, because once the children are adults, their dependency is ended. There's been talk in a couple of recent cases about the pressure on the court system with the fact-finding hearings like the one happened in this case already. In cases where this sort of behaviour is alleged, it's not suggested that it shouldn't happen. That just invites more as being relevant to the outcome of proceedings in which conduct is not one of the guidelines. Lady, I think that's all I want to say at this stage, unless there's anything else I can assist you with.
Thank you very much indeed. Yes, Mr. Howard.
Thank you very much, my lady, my lords. I wanted to start off with one factual point. It's right to remind the court that we did apply for a property adjustment order in the initial application, which is at core 282. So no one was taken by surprise. I want to concentrate on identifying and dealing with the issues, because I say that much of what my learned friend said conflated jurisdiction and exercise. And the reason he did that, of course, is because exercise of power is a judicial discretion, and we would say this court should not interfere with that unless he exceeded the parameters and was plainly wrong. And it is important to note straight away that he found dependency and he found special circumstances. And this was a judge steeped in the case. On the issues, it seemed to me that it boils down to 5 issues. The first one, that a lot of time was spent by my learned friend, can such a capital order be made for R, given that he was over 18 when the order was made, although under 18 when the application for capital provision and indeed everything was made. And I would like to adopt many of the points that were put by this court to my learned friend rather than repeat them, because I submit that they were very much on point. Second issue, is there jurisdiction to make outright provision involving purchasing a home? And if so, does this put children in a better position than children of a marriage? And we say the answer to that is quite clearly yes to the first, and to the second, no. Third issue, what are the non-statutory criteria for the exercise of the discretion, given that the statute does give unfettered power and a wide discretion? And we would say that it's abundantly clear, and I cannot really see what the dispute is, that it is special circumstances not limited to disability and not fixed, and the case law not being rigid, as indeed Mr. Justice Mumby said in Rien, a part of the judgment not read out. The fourth question is, was the judge, steeped in the detail of this case, plainly wrong to exercise his discretion on the facts of this case? And lastly, was the judge wrong to take into account past conduct as, of course, an insight into future conduct and future developments, or did he give it a prominence over the other paragraph 4 factors? And we say no. And my learned friend has just really said that this is all opening up Pandora's box on conduct. But of course, conduct was also central to many of the issues that were resolved in the mother's favour, which there is no appeal, including, of course, whether they should stay in that flat. So just because this order was made that is appealed does not mean that conduct wouldn't have been relevant. As I said, I'm going to adopt in relation to the first issue many of the points put to my learned friend by this court, but I wanted to emphasise in answer 1 or 2 points. Evolution of the case, well, it did evolve. He's quite wrong about that. If one looks at the supplemental bundle at A89, this was an agreed summary of the law, Melody. It's paragraph 35. I won't read it out unless the court wants me to. It is quite clear that it was common ground that there was power to order the transfer of the house on terms other than it reverts to the father at the end of the child's dependency. Secondly, if one goes back in the bundle to A24, you can see there this is...
Sorry, this was an agreed summary of the law.
Yes.
Was there, and you say, gives the court power to order transfer a house, etc. Is there anything in it about the point which you're addressing, the exercise of the power to make an order in respect of a child who has become 18 during the course of proceedings?
It's paragraph 20, provision for children over 18, paragraph 29 onwards. That was what was agreed. And you can see there's reference to Chamberlain, Keeley, TVS, and CNF, and TVS. So that was all put before. And indeed, the learned judge accepted the case law. He directed himself that he had to find that either that dependency continued or that there were special circumstances. And that's what paragraphs 29 to 34 is all about. So that was never in dispute. Those paragraphs went into dispute. And then I was taking the court back to A24. And you will see in the what is significant about this is that you will see in the box third up, it was common ground that the father was going to offer lump sums for R. So it's quite clearly...
Sorry, you've lost me. A24.
Additional payments sought in respect of children at A24. This is the father's document, and you can see in that box a lump sum was offered for both R and K.
Oh, this is the watch and the
Yes.
MacBook.
But of course, the argument now put forward is that there's no jurisdiction to do that.
No, I don't think so. I think the argument put forward is that it shouldn't be used for a house. I think he
No, but
specifically said watches, Apple, Macs.
But what my learned friend said is that because R was over 18, he had to make his own application.
I'm sorry, I thought you were talking generally. You're talking. You're dealing only with R, are you?
I'm only dealing with R. Yes. Which is why we say the case has evolved. Because quite clearly, when this document came, which was before the trial, it was accepted that the court could make periodical payments and lump sum for R. And if you now look at Schedule 1...
Sorry, wait a minute.
I'm sorry.
That's on that page is the power to make a lump sum for our R. Sorry.
Yes,
Periodical payments is presumably on
it's on the previous page. It's on A23, it's the third box up.
yes, or per child.
Per child.
And school fees too, presumably.
Yes. School fees, exactly. So the case did evolve. And this of course, is the position statement that we got on the 16th of January. And it was only when we got to trial that it was made clear that this point about R was being taken. Because if you look at paragraph 1 of Schedule 1, if my learned friend is right, there's no power to do anything for R at all. Which, of course, we say is the absurdity of his argument.
Well, he says no power absent him making his own application.
Absent an application, yes. So, effectively, no power absent. Yes. And, of course, he then said, well, no application was made by R. Well, there was no opportunity because the point wasn't taken until the beginning of the trial. And that's why we say it's relevant, of course, that, and my learned friend relied on this. If you look at the key issues identified on the 30th of July, this is not identified there. So it was a complete evolution. And the Robin point, well, Robin is all about people having notice of what was being applied for. Well, it was quite clear from the transfer of property, from the initial application, and indeed from our open offer, what we were applying for both R and K. And therefore, the farmer knew the case he had to meet, and if you're against me on the issue 1, we would say that quite clearly the judge was right to deem an application. But of course, deeming an application doesn't really deal with the substance of this case, because we would say that this was not either a lump sum or a periodical payments under paragraph 2. This was quite clearly a settlement and transfer of property order. And contrary to what my learned friend says, it was a settlement and transfer of property order, which took effect immediately. There was nothing more to be done. He keeps saying that this is an order made when K is 23 or whatever, and R is 27. No, the order is made now. And the order makes provision based upon the current circumstances now, their continuing needs, in of course, to adulthood, I accept that. The next point I would want to make in answer to some points that my learned friend made, he referred you to the Law Commission, and of course the real thrust of that was to align the law between illegitimate and legitimate children. And that is clear from Authorities Bundle 319. We don't need to turn up that. But of course, if my learned friend is right, what he advocates is a completely different set of circumstances for the illegitimate child. Because if you look at section 29(3), section 29 of the MCA, which is authorities 24,
Sorry, what page?
24, my lord. 29(1) says no financial provision order, including therefore a lump sum, and no order for a transfer of property shall be made in favour of a child who has attained the age of 18. And then it goes on, paragraph 2, about periodical payment shall not in the first instance extend beyond the date of the birthday of the child next following attaining the upper limit of compulsory school age, shall not in any event subject to subsection 3 extend beyond the date of the child's 18th birthday. And then, this is the critical, subsection 1 above and paragraph B of 2 shall not apply in the case of a child if it appears to the court that the child is, again, or their special circumstances. So, quite clearly, a child on jurisdiction, a child born in a marriage, can effectively, an application can be made for him or her under the MCA after they are 18, and indeed when, if either they're in full-time education or their special circumstances. And really that completely aligns what we say is the law under Schedule 1.
Does that completely align? Because to make an application under paragraph 1 of the schedule, the individual does have to be under 18 at the point the application is made.
Sorry, under paragraph 2.
Under paragraph 1, am I getting myself muddled? Under paragraph 1 of the schedule, the parent has to be the parent of a child, somebody under 18. And does that apply in the MCA context?
Well, you mean a parent of a child as opposed to what the child was illegitimate before? It's a child of the family, you could make the application. I'm sorry, I'm not.
I'm probably muddling myself, so don't worry, Mr. Howard.
I mean, my point is that the Law Commission wanted to align the law. And the law under the MCA is that a mother or a father can apply for transfer of property order, lump sum provision, if a child is over 18, provided either it is in education or that there are special circumstances. And what my learned friend is saying, no, that's not right under the Schedule 1. Even if the application is made when the child is 16, 15, and he gets to be 18 by the time. So there is not an alignment, and therefore Schedule 1 is discriminatory.
But where are we helped in... Perhaps I'm falling into the same trap as when we're looking at section 29, Mr. Howard.
Yes.
Obviously, subsection 1, no order for a child who's attained age 18.
That's the primary position.
The primary position. There we get our exception in subsection 3, which says if you've got your training, so on, or special circumstances, then it doesn't matter that they're they're over 18. Yes?
Yes, and there's no limit for when the benefit...
But where does it tell me that they can make, that the court can make the order, a fresh order, the first order, after the child has attained 18? So I accept completely, I mean, it's obvious. The application has to be made before they're 18, otherwise subsection 1 couldn't apply, could it? 29(1) couldn't apply. What I'd just like your help. It's how you marry up the argument on behalf of the father.
Well,
so where does this tell me, when you've made your application,
well, you've made your application,
but the child's turned 18, that the court can make a fresh order, a first order, notwithstanding the child is already 18 by the time the matter comes before the court?
Well, because the only section 24(1)(a) gives the power to make the application, to make the order, which is on A3, authorities 3. And of course, that's a different test as when the jurisdiction started. That wasn't really my point. What it says in section 24(1)(a) is that on granting a decree of divorce, you can make this application, you can make this order. My point was that there is no limit on making the order determinative on the child's age. Because you can...
If it falls within one of the exceptions.
Yes.
I accept that, get that.
That really is my point. I wasn't trying...
Could you answer my other point then, which is if we are then comparing Matrimonial Causes Act and the Schedule 1, where do I get that notwithstanding the child has attained 18 before the case is heard but following an application, that the court can nevertheless make an order?
Well, I don't think I can, because section 24(1)(a) gives a general power at any time on the granting of a decree, and then you ask yourself, well, and it says an order transfer to any child of the family, but of course that is different.
I think that was Mr. Pocock's point, that the definition of child, child of the family,
Yes.
And child in the Matrimonial Causes Act is different from
Yes.
the definition in the Children Act.
I accept that. Yes, I accept that. But I mean, my point was just, answering my lady's point is that section 24(1)(a) gives jurisdiction to make a transfer of property order to a child of the family. And then, is there any limit on it? Well, the limit is...
But they're not, my point is, and I may be wrong, I just want it clear in my head.
Yeah.
That's the whole point. They're not a child anymore. What you are saying, and Mr. Pocock is opposing, is he says if you've made the application before 18, fine.
Yes.
But there is no jurisdiction to make a first order, if I can call it that, once the child has become 18, because they're no longer a child.
Yes. Well, that's a section 158 point, isn't it? My point about the Matrimonial Causes Act is that was no more than that if you're talking about an alignment and disadvantage, it is quite clear.
I get that point.
That is really my point.
And just at the risk of confusing everybody a moment longer, just so I understand, is it possible under the Matrimonial Causes Act to initiate an application after the child is 18?
Yes.
For the parent to initiate?
Yes.
Yes. So in that respect, there isn't an alignment because...
No, there isn't an alignment.
Yeah.
No, you can issue...
And where do we get that? Initiating, making a fresh application in relation to a child who's over 18, a young person over 18. Where do I find that?
But you can
I
initiate...
think the answer is through the definition of child.
Yes.
A child is not limited to 18.
Yes.
It's just
It's a child of the family.
child of the family.
Yes.
And that's all that has to be.
And that is what is in section 24(1)(a). It's a child of the family. It doesn't say a child under 18.
I can't think of any authorities, or if anyone, perhaps the juniors, think of any authorities or occasions when a court has granted an order in the Matrimonial Causes Act in relation to a child that's for the first time, that they make a fresh application once the child is over 18?
Well, I've certainly come across it many... I don't think it's ever been... If you had a child at university, you could apply for an order for periodical payment. It's a child of the family, and that's under section 23, 1A, of course. 23, sorry, 1D.
For my part, it'd be helpful if someone could dig up some authorities
Again,
on that and let me have it in due course, not like this second.
The next point I wanted to deal with was that my learned friend said that the statute did not envisage any wider definition of a child. Well, we don't accept that. If you look at paragraph 3 at authorities 34, which we say is extremely important. This is on issue 1. The first point to make about paragraph 3 is that it only deals with duration, not jurisdiction. And what it says is that the term can start with the making of the application of an order. And if you read that in line with section 1.1 on an application made by a parent of a child, which of course my client did make an application on behalf of R as the child, that is what triggers the jurisdiction. It is absolutely clear. And then of course that is backed up by paragraph 3, because the court can make the term to be specified, and the order says in favour of a child, so it is still using the word child. May begin with the date of the making of the application, but A shall not in the first instance extend beyond the child's 17th birthday. B shall not in any event extend beyond the child's 18th birthday. So B is envisaging a child being over 18, which of course we say is in line with the wider definition. And then paragraph 2, paragraph B shall not apply in the case of the child if it appears to the court that the child is receiving instruction. That quite clearly envisages a child over 18 who is in education getting an order, and that can quite clearly be a first order. And then if one goes back, my learned friend's point, authorities 33, where a court makes an order under this paragraph, A, it may at any time make a further order with respect to the child concerned if he's not reached the age of 18. Well, that quite clearly is envisaging, and my Lord Justice Moylan put this to my learned friend, why is the word further there? It quite clearly permits an initial order, even though the child is 18 at the time that the order was made. And then if one goes forward, one might, please, to page 41, paragraph 9. Where an application is made under paragraph 1, the court may at any time before it disposes of the application make an interim order requiring either or both parents to make such periodical payments, etc., etc. Now, everyone knows the age of a child. That is demonstrably provable in any one case. Now, if it was the case that you could not make an interim order for a child that was over 18 at the time of the interim order, which is quite possible, then this paragraph is a complete nonsense, because the jurisdiction to make an interim order would not exist because the child would be over 18. And it's the I mean, that's my point about that. It's not, I think it was said in my learned friend's skeleton, oh, well, it's only an interim order, but it's an interim order that would be a nonsense because we would know the child would be over 18. So quite clearly, the statute is envisaging an interim order that can be made for a child who, at the time that the interim order was made, was over 18. And therefore, if you can make an interim order, it must follow that you can make a final order. There was reliance on CVF. I wanted to deal with that. Well, in that case, there was no application for capital. C and F is about the jurisdiction of the court as opposed to the CMS when there is a disability. That was the issue in that case. Not on point at all. And disability, of course, is defined, as one can see from the authority in Section 8, subsection 9 of the statute, Child Support Act. So the case is not saying that only disability can be special circumstances. It just does not say that. My learned friend relied upon paragraphs 630 and 632 of the Law Commission's report, but those paragraphs aren't about jurisdiction when the child is less than 18 at the time of the application. They're completely dealing with a child who is making an application when he's 18, and we accept if R had been 18 at the time of the application, then he would have had to make his own application, and that would have been done. So those were various matters. Now, before I deal sequentially with my 5 issues, I don't want to say much about the background, as there was a full chronology in the judgment, and as your ladyship has commented, a very full and long judgment. And I don't want to trawl all the way through. But I would like to emphasise a few points. And the emphasis that I would like to put before the court is that it was quite clear that we would say from all the background that there was a real likelihood that this father would financially manipulate the children. The father gave outright $607,000 for a flat in Fulham in 2017. He was then 20 and at university. And we don't just rely upon that. What we rely upon is that what presaged his deplorable conduct was that he tried to get the money back. And he tried to get it back by enlisting the subject children of this application support via threats. And that was quite clearly an instance of him trying to exert financial control. And of course, both these children know what he did because they know about the background. And all part of their vulnerability is which the judge clearly took into account, is what does K and R think about the fact that not only has A got a flat from his father, that his father gave it when he was satisfied with A and then became dissatisfied, and what's going to happen in the future?
You say there was a real likelihood that the father would financially manipulate the children. I think Mr. Pocock said that there was no evidence directed to that point, and the father was not asked about that point. Is that right?
Well, the point was, I was going to come to that, but it was certainly put to him in terms that he was manipulative and controlling of his children. And that, of course, comes from the findings of the recorder and indeed what the children told the Kafkas officers. And of course, I discussed with the learned judge how much of that I had to put, and that in the light of those findings that we didn't have to trawl through everything. So there were the primary findings. And there was, we say, therefore, evidence that he used money and power to influence young adults. It wasn't just that A was given a flat, it's also that he offered a flat for R, and the reference for that is Core Bundle 265. So, and he'd also offered the mother and K a flat in Kaliningrad. So, I mean, there was evidence that he was dishing out promises. There was also, and this was explored by the judge, there was clear evidence that the other 2 children were very much in his fold. The elder R had been made managing director of his main business, and the reference to that is Core Bundle 75. And it's significant if one looks at supplemental bundle C3 at D that he put it in this way: R is with me. That's what he said to the judge. And he clearly was influencing, we would say, them as adults, and both of them came to court to support him. And what we, of course, relied upon, and he was cross-examined about this, but by declining the court-ordered risk assessment, there was clearly going to be no contact, I beg your pardon, but it was also clear from the background that he was very fond of Kay, and he said significantly to the second CAFCAS officer, he may wait until she's 18 and can make her own decision. And that's core bundle 233. And of course, what the judge bore in mind, we say quite justifiably, is that he was then going to tell her, of course, or indeed before then, that the mother had fabricated everything, that he was the innocent party, and that, and this is the point, all she had to do was to come to Russia and all would be well. And it is added to that, of course, that in the 2008 crescendo of bad behaviour, he did want her to go to Russia and threatened to take her twice. And that is clear from the judge's chronology in early 2018. And as a result, we say that there was a clear evidential foundation for his finding that he might bribe, threaten, cajole vulnerable young adults facing the end of a luxurious lifestyle, and of course, riddled with worry about their future. And of course, the position is, contrary to the way my learned friend puts it, that worry could start immediately in these vulnerable children. I mean, they are of an age to be aware of what is going on and what went on, and one can see that from what Kay told to the CAFCAS officer.
So just putting it succinctly, as I understand your submissions, your case is that a finding that there's a real likelihood that a father will financially or seek financially to manipulate his children is sufficient to warrant a capital award in their favour.
Yes.
That's your case.
That is the case.
Thank you.
But I do rely on the fact that, contrary to my learned friend, that it isn't just a matter of saying, oh, well, it only bites at 27. I mean, this is something that, I mean, the children obviously know about now. They know that A was given money for a house. They know that there were promises about houses for them. And quite clearly, that's not going to happen now from him. And to have this FU fund is a comfort for them now. And of course, it is a continuing settlement. It isn't just going to bite when these children are whatever age my learned friend said. It's a settlement based upon their continuing need when, of course, they have different needs. And I wanted to just show the court how we say that the way the case was put was completely clear. If you go to the supplemental bundle, 93, C93, I beg your pardon. Is it 98? I'm sorry. I'm sorry, I can't read my writing. So this is I was asking questions at age. She's taking revenge for me getting married and for me having a small daughter. This is a woman's revenge. Question, a woman's revenge. You still want to shape the future of Roman and Katya, don't you? I'm thinking about how they are going to live.
Might not almost any parents say that?
What's unusual about that, Mr. Howard?
Well, it's unusual on the facts of this case when he didn't even do the risk assessment. Yes. I mean, he'd sort of that was what the prelude was to him having contact. He refused to go along with it, and so yes, we say this is all part of him not discharging his responsibility. And then at 99.
Just before you go on, I mean, that might be said to him be an instance of him discharging his responsibility. He's worrying about where they're going to live. And then he goes on the next page, who gave the mother the right to raise the children on her own.
Yeah, well, that is another way of looking at it, but it wasn't the way I don't think the judge took it. I mean, he saw all the evidence. If you go then to C99, there's a question at F, and this is clearly the judge asking this question. What do you think, if you could look into the future, whether do you think may happen when K is 22 and
but,
the home...
Sorry to interrupt, but just I think in fairness that one does, I know they're somewhat loquacious and rather lengthy responses from the father, but I think at BC he does try, rightly or wrongly, to put in context how he sees the various of his children, and seems to be saying, well, not everyone necessarily is treated the same, not everyone's had this bought for them.
Yes, no, he did say that.
Well, I think that is part of following on from what my lord said. That's important context, isn't it? Because your case is effectively as of right, because A got this property, the other two should be treated equally, and it's not fair if they're not. And he will manipulate them to either have it or not, and so the judge should did make provision to make sure that happened. He says no.
My main response is obviously because of the judicial findings is based upon the manipulation. Yes, I mean I obviously ran the argument that they should be in exactly the same position as A, but that's not the basis that the judge went along with it. I mean he made an FU fund, and on the basis of that he found that there was likely to be manipulation. But he did ask about it on this page. If you look under F, that question is the judge. What do you think, if you could look into the future, whether do you think may happen when K is 22 and the home that she and R and their mother live in goes back to you? My lord. So it was clearly have you thought about it? And effectively he answered that clearly the point was going through the judge's mind.
Can we look at the answer down to G on this?
Yes, his answer was he didn't want to give the children.
Well, Mr. Howard, his answer was that his policy, theory, beliefs was that you shouldn't give rich children too much money.
Yes.
They've got to work for the living. So simply for you to categorise it as he didn't want to give them it.
Well,
it is not worthy of you, Mr. Howard.
Well, I mean, I was using this to illustrate that the judge did put the point to him when he was giving his evidence. And obviously then the judge made findings. I accept that what he said was that he didn't want to give very rich children too much money now. Whether that was honest and whether that was the real reason, the judge came to a different view. That was my point. I accept, and I didn't want to say anything unworthy, that was his answer to this. But obviously the judge didn't accept it. And then, if one can look at the way that we put our case, learned friend, it's A38.
Still in supplementary content.
Yes, still in.
Thank you.
'69. And this is our note. Recorder Jen in her judgment emphasised the vulnerable position the mother found herself in as the unmarried mother of the father, as well as the way in which the F used his continuing financial support and by implication the threat of withdrawing that support as a powerful tool to control her. So, I mean, it was part of our case that he had used his financial support and control threats in order to control her. And if one, then my learned friend, of course, took you to the submissions, and they're in the supplemental bundle at 125.
Thank you.
See 125. And I'm not going to repeat what my learned friend took you through, but this was in his submissions, and of course we would say that Mr. Justice Williams put the point about the FU fund fairly and squarely to him and what was going through his mind. And you will see on 126, C126, that will leave them vulnerable to the financial muscle that the father is able to deploy. Mm-hmm. And we would say that my learned friend just didn't respond to that point. He did not say, and this is the important point, well, that hasn't been put properly to my client, I hadn't an opportunity to deal with it, I'm going to have to recall my client. He could have done that, but he didn't. He started going along about the authorities, and then at F, the learned judge came back. You're not really dealing with what I'm talking about, Mr. Pocock, and that is F to H, and then the reply, I'm going to submit there's no evidence they have such a need, no evidence that they need his property. There wasn't, and then over the page, all right, the court has jurisdiction, so it was a hypothetical point. And so it was quite clear at that stage what the judge was contemplating, and there wasn't any application, as I say, to recall the client, or indeed to make the point that is now being made, that he didn't have a proper opportunity to deal with it. And when I came to make my submissions, which are at page 183, at C.
Sorry, can you give me the page again?
C183 at letter C. Well, I said, normally one would expect a father to provide for them. It's your point about coercive control that you put to Mr. Pocock. I think
you're talking about the children when they're over 18.
Yes. I think that that is an issue which calls...
Mr. Howard, would you?
Sorry?
Would you normally expect that once the children are through education, you'd normally expect the father to provide for them, would you?
A
father, I should say.
You mean under the statute? Well, no, not as I
Just think of the authorities and the policy.
Yeah, not unless there is a continued dependency and special circumstances, and this is what this is all about. I think that is an issue which causes me some certainty. That happens in a case if you have someone who's been found, as the father has been, to be manipulative and controlling, and who has on the evidence attempted to terminate their occupation of the home when he's cross with them. What happens in 7 years' time? If the children then have to leave their home, how will the father behave towards them? Will he use his financial muscle to seek to get them to go to work for him, or do something else, or they will have nothing? Yes, that is what I mean, or they will have nothing. They do as he says, he will give them something. If they do not, as he says, they will have to stand on their own 2 feet. Well, he might say that's a good thing anyway, but in terms of coercion and control, it seems to me it is a worry, shall we say. Yes, why should they suffer? Because my client justifiably stood up to this father. That's what it amounts to. And then the judge significantly says, well, the children have as well, i.e. they stood up to it. The children have. A and R both have. They both have. Your lordship can ensure they do not suffer financially until they leave university. We say your lordship should address in their interest the coercive control after they leave university. That is really our point. It is clear, we'd say, from the evidence that A and R are being set up in Russia. Of course, my client is not going to be able to help at all because she has no money at all. So what we say is a combination of what the judge put to my learned friend and that exchange made it quite clear that we were relying, and the judge was contemplating the possibility of coercive control and a fund to stop that after they left university. And there was no application for to recall the husband, the father, or indeed to say, well, the evidence didn't justify it, because we say the evidence quite clearly did justify it, that he was a manipulative, controlling man. Can I then deal with the issues? Obviously, I've touched on them one by one. Issue 1, I think there are 7 main points, and
issue 1.
Issue 1 is can a capital order be made for R, given that he was over 18 when the order was made?
And you've dealt with that.
I think I've dealt with that.
So you want to?
I'm just seeing that just to summarise, it's the wording of section paragraph 1.1. Secondly, if my learned friend's right, in his construction, there's no power to make a periodical payments order, but it's clear there was power because of paragraph 3.2a, and the discrimination point I've made, the enormous motive to prevaricate. I think that was put to my learned friend. It's in our submissions, and there's a support from paragraph 6.29 of the Law Commission report, and support from the fact that you can backdate, and I dealt with that, the paragraph 3 point, and of course the interim order, paragraph 9, schedule 1, and paragraph 9 of schedule 1, the interim order point, which I dealt with earlier. And we dealt with this in paragraphs 5 to 27 of our submissions, and Mr. Justice Williams dealt with it in paragraphs 34 to 43. Can I then turn to issue 2, which is there jurisdiction to make outright provision involving purchasing a home? Well, there is some reliance on the heading of Schedule 1, which is, of course, financial provision for children. But against that, much can be allocated towards them or for their benefit, we would say, after they're 18, when they cease to be children. So there really is nothing in that point. If there is an application, and I'm not going to repeat what I said on issue 1, if there is an application, then the court can make any one of the menu of orders, including 1.2d and 1.2e. It says, of course, the settlement has to be for the benefit of the child, but we would say this settlement is for the benefit of the child. Otherwise, there is completely unlimited power in the statute, and the statute does not say there has to be a reversion or the interest ends either when the child in question is 18 or ends tertiary education. It's a completely unlimited power. Therefore, it is perfectly possible, jurisdictionally, for it to be a reversion to the child when the settlement is no longer needed for the mother and the child when the child is an adult. It is also, we would say, if you're limiting it to benefit, it is of benefit to a 17-year-old child to know, if they have been through a very bad time, as these children have, that their early adulthood is secure. The fact of an unlimited power in the settlement is shown by the power to transfer, which is completely unfettered in 1.2e. Doesn't even say it has to be for the benefit of the child, though that is obviously implicit, but it clearly is an unfettered power. It's emphasised by the fact that the court must consider all the circumstances. It's a very unfettered power. Now, of course, if a court can make an outright transfer, which it can, then clearly there can be a transfer of property order and by implication a settlement which benefits the children as adults. Because transfers can't be reversed. They're once and for all payments. So by necessary implication, the statute envisages benefit forever. Because if you transfer a property, it can't be reversed. And that's by necessary implication. And there is no justification at all for my learned friend's gloss in his skeleton that it only covers transfers capable of providing benefits when they can't be exhausted, e.g. cars. Well, obviously, you can transfer a car, you can transfer a computer, you could transfer a work of art and the car deteriorates and therefore it's not forever. But certainly a car could continue well into adulthood because even in this case, I think the order says that the second or third car will be provided in 2027. So that clearly is going to go into adulthood. But it isn't what the statute says. And all of this was anticipated by the Law Commission report, and perhaps we'll look briefly at that, which is at Authorities Bundle 320. And paragraph 6.6, we say makes it quite clear what the Law Commission envisaged was a once and for all settlement, being possible jurisdictionally. And it's particularly the passage beginning about 6 lines up, moreover, it could well be particularly desirable to give the court power to make what would often be intended to be a once and for all settlement in those cases where the father intends to have no further relationship with the child. And pausing there, by not having the assessment, that is really what the father has determined here. Just as courts lean against making substantial capital orders in favour of the children of marriage, so we would not expect those additional powers to be frequently exercised, but they could be useful in some circumstances. So certainly the recommendation was for once and for all settlements. And the learned judge, as we will see, made it quite clear that the power would only be exercised sparingly and in very limited circumstances. So he was entirely in line with that. And that has a resonance, of course, with what Lord Justice Scarman, as he then was, said in Chamberlain about the father or a husband discharging their responsibilities to the child. And we would say that isn't just financial responsibilities, that's parental responsibilities. And he really has not discharged his parental responsibilities to these children since 2018. The court determined he should have a risk assessment, he refused, and the result is that he doesn't exercise his parental responsibility at all or in any responsible way. The next point I make about jurisdiction is that there is no Court of Appeal authority on this point at all. That is, whether there is or is not jurisdiction. Obviously, Re P, at paragraph 45, Lord Justice Thorpe said that the House would ordinarily, that's the way he put it, be transiently required during minority or until further order. he made it clear in paragraph 19 that it was a highly discretionary jurisdiction. And Mr. Justice Bodie in that case said generally the children need accommodation during minority. So there was clearly no prohibition in that case on a once and for all settlement. And of course that was not a case which involved the issue that was before Mr. Justice Williams and is before this court, where there was conduct and background facts which indicated that children would be vulnerable. The child in Re-P had no particular vulnerability, except that it needed money. And if you go to the other Court of Appeal authority, which is perhaps of some relevance, but before we get to that, if one could look at 2007, authorities 2007, something in Re-P. 207.
You said 2007.
I am sorry. 207.
Thank you.
Not that big a bundle.
No.
Paragraph 44, 5 lines up from the bottom. I say that because the purpose of the statutory exercise is to ensure for the child of parents who have never married and who have become alienated and combative, as here, support and also protection against adult irresponsibility and selfishness, at least insofar as money and property can achieve those ends. And we say that what this judge found on the part of the father was adult irresponsibility and selfishness, that he was a dominant man who wanted to get his own way always and wanted to control everyone by money. And so it comes within that dicta. Then, of course, it was dealt with, I don't think we need necessarily turn it up, in Re, Lady Justice McClure, in paragraph 9. She referred to the well-established practice of maintaining a reversionary interest of the father. She did not deal with jurisdiction as to whether you could make it at all. And of course, the observations in that case about you had to protect against providing a windfall for an unmarried mother after the children were grown up, well, Mr. Justice Williams took into account that as a possibility. He did not find it on the facts. And of course, there is no evidence that my client was pressing for an outright transfer to her 2 children because of her obtaining a windfall. She does have, as the court knows, her own property, which she can utilise in due course, the property in Kaliningrad. So there was no evidence that getting more for the mother by the side wind applied here. And we also rely on the comment of Lord Wilson in Birch, where Parliament has conferred jurisdiction on the court, there's no scope for a court to say part of it doesn't exist. Parliament gave the power to make a transfer of property order. There must be circumstances in which that would be exercised. It's a once and for all payment, and it should not be limited. Nor did Parliament state that there always has to be a reversion. Could have said that, because it set a limit on the benefit of periodical payments in paragraph 3. It did not set any limits on transfer of property. And I accept that although the statute gives unfettered jurisdiction, first instance judges, while acknowledging the jurisdiction, have circumscribed its exercise to special, exceptional circumstances, or where the dependency continues. But that was the law that the learned judge applied. But what is significant is the case law does not limit that to disability. What it does is apply the Matrimonial Causes Act jurisdiction, Chamberlain in particular, and that was completely followed by Mr. Justice Williams. And there are really 4 cases which go along that line. It's J and C, MT and OT, paragraph 87, Re-N, and I'll come back to that, A and A, which is my learned friend referred to, which is Authorities Bundle 58, where Mr. Justice Ward, as he then was, talked about a distinct trend against outright transfers and not being a reversion, and that a property adjustment order should not ordinarily be made. But I'm not trying to say that this is available to the court on all occasions, but it is a power. It's a power that can be exercised, and it's a power that should be exercised if the facts of the case show dependency or special circumstances. And as I said...
When you say dependency or special circumstances, not sure that I, speaking for myself, I quite follow. When we were looking at Re-N, it seemed to me that that contained quite a helpful summary of the legal position. And Mr. Justice Mumby, as he then was, alighted on special or exceptional circumstances as being the conventional limiting factor, not special or exceptional circumstances or dependency. So do you accept that it's special or exceptional circumstances, which, because the provision provides continuing support for what might, as a result of those circumstances, be a continuing dependency. But I don't see it as an or, is what I'm trying to...
Well, I only put it in that way because that is the way the learned judge put it. He found a dependency because of the conduct, and he also found special circumstances. But of course, they could amount to the same thing. I mean, obviously, a dependency clearly continues in relation to a disabled child. We would say that a dependency also continues whether that disability is, as it were, as a result of the abuse they've suffered.
But what form does the dependency take?
Well, the dependency takes the form that they need to be protected in their vulnerable state, that they are not like children in a conventional Schedule 1, which is just about money. They leave university, they don't have any scars of emotional abuse, and they start on their life. And the normal thing is that their dependency ends then, and there are no special circumstances.
That's not the basis the judge made the award, though, in this case.
Sorry, no, he said that they had a vulnerability.
Yeah, I follow the vulnerability point. In terms of dependency, as a matter of language implies somebody being dependent on another.
Yes.
Now, that's obviously true in the case of a minor child or potentially a young person in education. But why would a 30-year-old be dependent on their parent? I mean, obviously they would be if they were disabled or the like, but or to put it another way, is this really a special circumstances case rather than a dependency case because it's hard to see the dependency?
I think it is predominantly a special circumstances case, but I'm really conceding that there's an overlap between the two. I mean, if a child bore the scars of whatever had happened to it, and it dropped out of university, the evidence was that, not going to get a job. I mean, that child would be dependent, we would say, in the terms that Mr. Justice Mumby said. I mean, a parent is just not going to wash their hands of that child. So it's not I don't accept dependency necessarily ends at university. You can be dependent upon your parents because of the emotional scars you've got or whatever. And that's really what the judge decided, that these children have had the most terrible experiences. They are undergoing therapy, and obviously he's looking forward for quite a long way, but as I think he put it, how do children ever get over this when they're told to go and kill one of their siblings or the like? And that's why they might be dependent because of his conduct. But
But-
that also would be special circumstances.
And I'm not sure I'm disagreeing with you, Mr. Howard, but supposing that you're scarred by being told to kill your sibling or whatever, that doesn't of itself obviously make you dependent on the person who told you to do that. It might even
No.
point in the other direction.
Well, you're dependent on the only parent who's exercising, as it were, parenting over you. But of course, I suppose the point I'm making, perhaps very badly, is that it's a bit of a myth that all of a sudden that people move out of university and they're not dependent on their parents in any way.
But that's a myth that we all recognise
Yes.
from experience of the world, but is not actually recognised in ordinary circumstances under either the Matrimonial Causes Act or Schedule 1, because they work on the policy basis that once a child is through university or apprenticeship, as it's very often now, that they're on their own 2 feet.
Yes, unless
So
there are
we
special...
we can't apply what might be regarded as middle-class mores to
No.
carrying on supporting post-university children because they are doing unpaid internships or whatever and living at home.
I don't think that's really
into,
I don't think that's really what I was saying, my lady. I'm not saying that this order is justified because these are middle-class children who ordinarily might get help because of internships. What I'm saying is because of the exceptional circumstances of this case, they are likely to be vulnerable at that stage.
Well, they may be vulnerable, but if you're looking at special circumstances that would lead to making what I think you've conceding would be a unique order at the moment, as was made in this case, surely then there should be some at least psychological evidence that shows that these children have been so affected by the abuse that they are going to be rendered either incapable or less capable, for example, of holding down a job or obtaining employment or whatever. But there was none of that here.
Well, there were the findings. I mean, the learned judge dealt with that. I don't know if your ladyship looked at that in the core bundle. I think it's at 215, I think.
So is this in the exchanges? Is this?
No, this is the second judgment.
Oh, thank you.
It's 216. Paragraph 32. Because he was asked to give permission to appeal, and he dealt, at this further hearing, he dealt with permission to appeal from 215 onwards. And you will notice, if you go back to 215 at paragraph 29, I start from the fact that this is a very fact-specific case, self-evidently from the judgment. And then he goes over the page, paragraph 32, the decision to award capital being based on the vulnerability of the children when there was no medical evidence. I do not consider that as a realistic prospect of success. My conclusion was not underpinned by, as it were, a medical evaluation of the children's vulnerability. It was based on an assessment of the entirety of the evidence relating to the behaviour of the father, the vulnerability of the mother and children in the light of the findings that's been made, and my assessment that in the future there was a real possibility or likelihood he would seek to manipulate the then adult children by deployment of his financial muscle.
Yeah, well, look, that's where I need help, because, I mean, if you sat in the family division as long as myself and Lord Justice Moylan done, I mean, watching absent parents manipulating their children with money is routine. It's not special circumstances. And that when children, that absent some evidence of a psychiatric, psychological vulnerability as a result of the abuse, I'm still not sure why the fact that he may carry on behaving badly when they're adults justifies a wholly exceptional order being made.
Well, it's not. It isn't just a matter of pure manipulation. I mean, obviously there are cases when a father can say, "Oh well, if you do this, I'm going to buy you another laptop or something." I mean, this is of a different order. This was a man who, when he was not getting his own way in 2018, asked effectively to do violence against his elder brother, against his mother, and who
But we're not talking about that. We're talking about what the judge based it on what he said was going to happen in adulthood.
Yes, and therefore,
which was financial manipulation. If you don't leave your fun job and all your friends in London and come back to the hill farm in Cumbria within the next 18 months, that's it. I'm going to sell up and give the money to your younger brother. Now,
but in that instance, my lady, that the child in question has got no vulnerability particularly. I mean, that's just a pure manipulation. You haven't put into it that this is a damaged child.
But we've.
I mean,
I don't want to go around in circles with you, Miss Howden.
Just following it up, if we look onto the Kafkas report, which look, for example, at page 229, dealing with K.
Yes.
We see in beginning of paragraph 6, K is a confident and friendly young woman. Paragraph 8, she has many protective factors in her life, such as talents and interests, a strong relationship with her mother and brothers, a good friendship at work, and a positive school experience. These factors outweigh the adversity Kay has experienced and contribute to her resilience, and so on. So, accepting the findings in relation to the abusive behaviour, can one, without further evidence, expert evidence perhaps, conclude that she has been rendered so vulnerable that the rest of what you suggest follows?
I'm just trying to look at the date of this. This is
March.
This is 6th of March 2019. Mm-hmm. This is about 14 months after all contact stopped. And it is obviously at a time when she had been perfectly secure in the very large apartment. And of course being looked after by her mother, who by all accounts was an exemplary mother. It was quite clear from that she was making a recovery. But of course, also, this is in the second report, she wrote that letter. And the letter is at 231. And the letter, quite clearly, we say, exhibits the underlying pain and difficulty of her situation.
But the letter, the Kafkas report was written after the letter, and it says, in the meantime.
Well, just after the letter was written on the 28th of February.
Yeah, she doesn't want to completely sever her relationship with her father, and should be comforted and aced and still thinks and cares for it. To achieve this, I recommend he should write once a month. That's not denying the pain that's, as you rightly say,
yes,
is expressed. But
I was just responding to the point about resilience.
Yeah,
I mean,
well, she's, thank goodness, after what she's been through, she seems to be extremely resilient and put in protective measures and able to get on with her life.
Because, of course, the court protected her. There was the injunctions and...
But why does that mean that this resilient young woman who's doing fine with her exemplary mother should, in X number of years' time, receive this very substantial capital payment?
Because, as the father made clear, it's at 233, which is dealing with the risk assessment, 232. And on 233, the fourth line down, Mr. A suggested he may wait until K is 18 and can make her own decision.
Yeah, exactly. She'll be 18, she can make her own decisions.
But, I mean, the point, I don't want to be repetitive, but the point I make about that is that is when, up until then, she's now 16, that is when the influence can come. Because we know from the judgment, and indeed from his evidence, what the father is going to tell her, that all of this is, a fabrication by her mother, that she must come back into this new camp, and of course, if she comes back into the new camp, then she'll get untold riches. And of course, that is the FU fund in a nutshell, and that is very different, if I may, to your ladyship's example about just someone saying to their 17-year-old, unless you become a farmer or whatever, you're not going to get anything, it's all going to go to Billy or something. I mean, that is not a damaged child, but this is clearly, I mean, the letter, we would say, indicates the underlying pain of this child, and she has been through some quite terrible experiences. Of course, she is showing a resilience at the moment. She doesn't see her father, she's secure in her home, but I mean, as she comes to 18 and begins to think about it, what the judge considered is the father would then come into the picture again and would be luring her to Russia. He threatened to take her to Russia, if you remember, and she was very scared about that. So that's when the difficulties come for her. And this is not the classic case of a child who is dependent because of an internship. It's a child, we would say, who is vulnerable and damaged, which is the findings that the judge made, and we would say they are impeccable findings.
But does the judge find any financial impact or consequences from that vulnerability? Because it might be said that he sort of starts in the wrong place, and that he starts from the proposition that the father should be giving the children when adult money, but he may not because he's manipulative. And they may be vulnerable to that manipulation because of their situation. Well, that, as I say, might be seen to be starting from the proposition that he should be giving them some financial support provision at that time. But that completely begs the question, doesn't it? Because the question is whether the powers under the Act should be used to require a parent to make financial provision, which is usually directed to maintaining them in some way because they require maintenance. They have a dependency. They're obviously dependent when children, but conventionally not dependent financially once adult, absent some factor which makes them financially dependent.
The judge, I mean, we can look at the way he put it in a moment. My understanding was the judge started from the proposition that the children would be vulnerable to influence, bribes, if you like, at that stage.
Mr. Howard, at page C184, the judge said, in most cases one would expect a father to make that sort of provision. I think the question here is whether he will make that provision without there being some quid pro quo from the children.
So was this the core button?
Supplemental.
Sorry.
C184, because that would appear completely to reinforce my Lord Justice Moylan's.
Sorry. Did you, which page did you say?
C184.
Yes. I've got that.
Right, if E, we have you, Mr. Howard, saying social and economic climate changed. We say absent coercive control with children in London with a man of his wealth. He'd help them on the housing ladder, he'd help them get their first job, internship, etc. Mr. Justice Williams says, well, with most of these fathers, we wouldn't be in court if he was going to do it anyway. But then he goes on, but in most cases, one would expect a father to make that sort of provision. I think the question here is whether he'll make that provision without there being some quid pro quo from the children.
Well,
and he went on to make the order so that they don't have to give that quid pro quo. so that he would be like a father in the present day.
The point I make about that, the paragraph that begins where I start talking about the social and economic climate has changed very considerably. I didn't succeed on that, and I'm not trying to say that that's why the order was made. And then Mr. Justice Williams is obviously dealing with that point, but that's not the basis that he made the order. What he said is that you would expect a father. I think the question here is whether he'll make that provision without there being some quid quo from the children. Well, I mean, I don't know, because I was putting the point about, the social mores that your ladyship put to me, but I don't know quite what he was meaning about quid pro quo. But what I think one ought to look at is what he said in the judgment, because I don't think he did, as it were, put the cart before the horse there.
He also said that on 183, in the sense that he was responding to a point that you had made in the middle of 1383. Normally one would expect a father to provide for them, and then coercive control. That is an issue which causes me some concern, must be.
At D.
At D. So he's seeking to protect the children from the manner in which he thinks the father will seek to manipulate or control them by promising, giving financial support. So what we need to identify in the judgment, if it's there, is the judge saying that the financial support was otherwise justified for some other factor. That's just what I'm...
Well, I don't think he does say that it's justified.
He doesn't.
Doesn't, from some other factor. I mean, he deals with this. Go out to the call bundle.
Sorry, we keep taking you out of turn, Mr. Howard.
70.
So, sorry, just for the person I know, you accept the judge did not decide that the children required financial support continuing into adulthood, independently of this manipulation point?
No, that's fine. Yes, I accept that. I did run the social mores point, but I lost on that, and I'm not going to have another go on that. It's not in we didn't put in a respondent's notice, but I did run that. But and obviously that's the point my lady has put to me. But the social mores and what wouldn't expect, but it's.
I expect you put the supplemental bundle to one side, but just looking again at page...
Sorry, I'll come back.
Sorry, just looking again at page 183, at the end of the passage that you were being taken to a moment ago, we see seemingly what the judge has in mind. Will he use his financial muscle to seek them to get to go and work for him, or to do something else? So the idea seems to be, well, the father might say, unless you come and work for me, I'm not giving you any money. But that can't be enough to warrant, to amount to special circumstances.
What the judge had in mind, and we'll look at the passage in a moment about the special circumstances, was that these children obviously have made it quite clear where the truth lay, that their father behaved appallingly towards them and their mother. But there is obviously the pain, because Kay once had a very good relationship with him, and she's obviously conflicted because of that, and her letter speaks volumes of her, we would say, pained state of mind about this. The father quite clearly, despite the findings of the recorder, which was a 3-day fact hearing, in which he ran the case that the mother had made all this up, she was a fabricator, she was turning the children against him. And he ran the same point again when he gave his oral evidence before Mr. Justice Williams, that he was going to forgive the children, that the light would descend from their eyes, etc., etc. And we'll come to that in a moment. And what the judge was getting at is the children need protection against coming under the pressure from this man who will clearly want to get them to return to the fold, go back to Russia, and of course be in the thrall of someone who was an abuser. And what this does is that it gives them the financial independence to stand up to it. That was really the core of his findings. And he did not say, despite the, I mean, this was a discussion with me when I was running this other argument, he did not find that the reason for making this order was that these were upper middle class children. They were living in the lap of luxury in a 10 million flat, and it was going to be catastrophic for them, for financial reasons, to have to leave 6 months after Katya gave up the university. They didn't, that's not the basis that he found. He found, having seen this man over 2 days give evidence, having read the papers for a day and a half, having read the recorder's judgment, that it was likely that he would use his financial muscle to manipulate and control them, and they needed protection against that in the light of their vulnerability. And we say that that was perfectly appropriate special circumstances to make this order, which he said was an order that would only be made in very limited circumstances indeed. And that is borne out by, we say, what is his careful judgment from paragraph 158 onwards. And really, one ought to turn to that. And I mean, I may have, I hope I haven't summarised it incorrectly.
No, it's all about financial control.
Yes,
Or use of financial control.
yes. By a man found to be,
But as my lady said, that's not uncommon.
it's not uncommon, but what the difference here is, I don't want to go on repeating myself, is that these are vulnerable children.
But so are many, many, many children who've been within a family where there's been coercive, controlling behaviour, domestic abuse, endless court hearings. You know, they're regularly, it's quite appalling. We all know how dreadful it is for the children, and we have no evidence before us, and I don't think there was before the judge, other than the fact that one of the children, thank goodness, is very resilient, to tell us that this takes us beyond what unhappily is a not uncommon state of affairs, so that this very unusual order should be made.
Well, there isn't
It's children's
obviously
favour.
there isn't obviously any case in which an order like this has been made, but that's not the end. of it.
Understood. You know, there's a first time for everything.
There's a
I
first time for
absolutely-
everything, and secondly, if I mean, I come back to it being fact specific. I mean, it's going to be impossible for me to go through every possible scenario where there's been manipulation, but one has to concentrate on the facts of this case. I mean, there's manipulation and there's manipulation. And this, we would say, is of a quite different order. And the judge's remark, which we'll look at in a moment, well, if this isn't exceptional, I don't know what is. And it's not just, I mean, we would say that in a matrimonial case or in any Schedule 1 case, I mean, if an order could be made which can protect the children against what they have suffered, then it should be made. And if that goes into adulthood, well, so be it. I mean, if it's therapy, then that should go into adulthood. But I mean, it's all fact specific, and it's going to be impossible for me to, as it were, unravel every possible case. But I suppose my short answer to your ladyship's point is that this is an exceptional case. It isn't the run of the mill where there's been a small bit of a manipulation. This is a case of very vulnerable children who have been damaged.
It can be very large, it can be very serious manipulation over a very small amount of money.
There can be, but I mean, of course, it's a matter of marrying up the manipulation to what you can do about it. isn't it? I mean, obviously, if the manipulation is over a small amount of money, then the court is not going to make an order in relation to that. But this was different. So if I could turn, I don't think there's any need to, I mean, paragraph 158, the learned judge, sets out what we submitted. Paragraph 159 makes it clear the route that he's discussing the route. Paragraph 160 is what Mr. Pocock had to say of it. Accepting exceptional circumstances. And then he says in paragraph 161, considerable force in his submissions. It seems to me that the circumstances in which capital provision can be made which will benefit a child into adulthood will be very limited indeed. And I say that that deals with my ladyship's point, that this is not, he did not treat this as a run-of-the-mill case when there was just some manipulation. All of the jurisprudence supports this approach and confirms the rationale for it. Having said that, it's clear from the authorities that in some circumstances where the court identifies some continuing dependency, such an order can be contemplated. Obvious example would be that of a disabled child who might need a specially adapted home long into adulthood. However, I do not think that dependency is necessarily so narrowly defined. Dependency connotes some form of vulnerability, which is why the judge found dependent, or need continuing from childhood into adulthood, which can be remedied by capital provision. I'm satisfied on the evidence I've read and heard that both children carry with them a vulnerability arising from their childhood, which will endure into their adulthood. So that was his finding.
Can I just pick that up? Dependency connotes some form of vulnerability. But the judge has turned that round and said that vulnerability establishes some form of continuing dependency. Does he, or does he not?
Dependency. Well, he's saying that...
Well, he doesn't say that. He just says dependency connotes some form of vulnerability.
Yes.
But with greatest respect, what does that mean?
Well, if very vulnerable children... I mean, it is rarely saying that you shouldn't look at disability purely in physical terms.
Yes, but he's talking about a vulnerability.
Dependency.
And the vulnerability, if one goes on to 162, sorry, I probably am making go round in circles, taking myself round in circles, is to being manipulated by the father.
Yes.
That's the vulnerability.
Well, not just, because he then goes on, I'm satisfied on the evidence that they carry a vulnerability arising from their childhood. The children have seen a psychotherapist and the preliminary...
I understand that, but
Yeah.
It's the vulnerability to being manipulated by their father from which they need to be protected.
Well,
Is that a fair analysis of what the judge is saying?
Well, I would add, my lord, that it's a vulnerability based upon the fact that they need a psychotherapist as well.
Well,
But that seems problematic in the sense that the judge says, well, these children are scarred. And then he concludes, seemingly, that there is a vulnerability which can be remedied by capital provision.
Yeah.
Now, why does scarring give rise to a vulnerability that can be remedied by capital provision?
Well, then you come to paragraph 162. Because the vulnerability makes them susceptible to the manipulation and control.
So the thesis is they are scarred,
They are scarred.
therefore they are susceptible to manipulation and control. What's the evidence for that bit?
Well, and they are in the difficult position of their occupation coming to an end, and therefore they're vulnerable to
But
any
they've
pressure.
been in that difficult situation with or without the scars. So where is the evidence?
Well, it makes it worse for them. The scars make. I mean, these are not the normal, robust children who can perhaps. I mean, the evidence is clearly that this is a man who's very difficult to stand up to.
I follow that, but the thesis is, as I understand it, the scars make it more difficult for them to stand up to him. And where's the evidence for that?
Well, I can't. There is that K is conflicted, as I've said, and that, I mean, vulnerable children are, we would say it's quite obvious, are more susceptible to coercive control pressure.
I mean, you'd expect all children potentially to be vulnerable to their father saying, if you come to Russia, I'll make you very rich. If you stay in London, you'll have nothing. But that's different from saying that the scars make them more vulnerable to that.
Well, because the offer has been coming from someone. I mean, they get the dilemma of that, if you like, and it is coming from someone who is quite clearly seeking revenge on their mother and is going to say, oh, well, you know, the consequences of all this is you've got to now accept a new narrative, which is that your mother fabricated it all and has stopped me seeing you, which is obviously what he wants to say.
But the children have made it clear to the Kafkas officer that they don't buy that.
They don't buy it now, no. But of course now they're completely secure. So it's much easier. They are younger, particularly Kay is younger, and they have stood up to their father. But of course, the judge's point is that when they have to leave this flat, they are going to be much more vulnerable to that sort of pressure. At the moment, the pressure would probably be a waste of time, though it could start. I mean, there's nothing to stop it starting. But I mean, they are living in an extreme. They have all their needs at the moment, but that's not going to continue forever. Can I go on with this paragraph 161, because I do say it's important. Quite clear at the bottom of 143 that they need therapeutic support as a consequence of the father's abuse. So they are damaged. And that was accepted. It was put by me to the father that he accepted they needed therapy, and he did accept that. Quite how one comes to...
I don't know why you're reading this. Sorry to jump in. We've all read it.
Yes.
Probably more than once.
Well, my submission is, and I won't go on reading it then, is that the judge said that this was an exceptional case. He was steeped in the case, and he made the findings that he did. And I rely on paragraphs 161 and 162.
Only by giving them the means to say no to their father's exertion of financial control can they be properly protected and provided for the future.
Yes. And be able to resist his control. And of course the finding in paragraph 161, used to getting his own way, determining what the family does, hopes the scales will fall to their eyes. I mean, that's what makes this exceptional, we would say.
Yes, thank you.
I obviously have probably gone to issue 5.
Well, I think I think that's been very helpful because
Because I wasn't.
I think that you've rightly, if I may say so, focused in on the area about which we've expressed our greatest concern.
Yes. I was still dealing, I think, with issue 2.
Which was?
I think we could.
Again,
Is there jurisdiction to make an outright provision, and is it better than? Can't read my next word.
By way of purchase of a house.
Yes.
Is that it?
That was the jurisdictional.
That was jurisdiction. Well, we sidetracked you certainly into exercise, didn't we?
I think so, yes. But I did want to say one or two things about issue 2, if I might. I would like to resist the point that my learned friend makes, that the order just takes effect when these children are adults. It is, we would say, a fully effective order now.
When you've told us that it's a once only order, it's made at the time, it's part of the settlement, and that's that. So it's to try and sever them is not, it's not appropriate.
But it isn't just giving them benefit as an adult. That's what I would say. It obviously
Well, you say it gives them emotional security now and fiscal benefit as an adult.
Yes. Well, and they anticipate fiscal benefit. And it gives them benefit now because they will know already about his financial muscle. They know that he tried to evict them from their house. All of that was known.
Well, you say evict from the house. Have I misunderstood? My understanding was that his case was not that they should be thrown onto the street and fend for themselves, but that the house in which they're currently living was too expensive and not necessary, and that a different house could be provided for less money?
No, in January he gave notice that they had to go.
Yes, but I'm talking about his case.
Oh, yes, but I'm saying the children know that there was a time when he tried to...
Oh, the mother told them, did she? I mean, so the children have that knowledge.
Yes, the children have that knowledge. Well, it was a possibility because his company said, we were going to get the police to... I mean, it's all in...
No, I've read that. I want to be clear about the case at trial. The case at trial was a smaller property. Yes. No, that is certainly right. But I mean, because they know about what has happened and they know about the abuse, then the order gives them reassurance now and benefit now. The order is made now when they are either a child or we say was a child at the time of the application. And it takes effect now when the order is made. There's nothing more to be done. There's no deferment. And that was the clear intention of Mr. Justice Williams. There's a reliance placed on Phillips and Peace. We say that is completely misplaced. We aren't trying to get round a statutory bar as in Phillips and Peace. In that case, the decision was that if you couldn't make periodical payments, you couldn't make periodical payments by the back door through a lump sum. Well, there is power to transfer property now, and there is no bar on that being once and for all. My learned friend relied on the proposition that the order puts these children in a better position than the children in divorce, and I wanted to deal with that. I've already made the point to the court that there is power in divorce, including if the children are over 18 when the application is made, if they are either in education or special circumstances. And it's quite instructive to look at what the jurisdiction was that Lord Justice Scarman dealt with in Chamberlain, and that is, if we could look, please, Authorities Bundle 91. Before just looking at the passage, what I say we derive from this is Lord Justice Scarman did not doubt the jurisdiction to make an outright transfer. He merely said that Lord Denning in Wachtel gave valuable guidance for a large number of cases, but not for this case, and in Wachtel, Lord Denning talked about an outright provision. He made it clear that all these cases were fact-specific. He made it clear that we were dealing with flexible and wide-ranging powers. And of course, he had that proviso that my learned friend dealt with at the bottom of page 91, provided that the parents meet their responsibilities to the children as long as the children are dependent. And we say that has a resonance here. That isn't just financial responsibilities, that's parental responsibilities. And we say that this father has not meant those.
met those. And what is quite interesting as well, which of course...
Doesn't that take us back to conduct?
Yes, but
in a maintenance application, an old-fashioned maintenance application, you find out what the needs are, what's required. You don't then say, and actually he's always late for contact, or the rugby boots come back filthy, or he shouts at them, or he doesn't put the seatbelts on in the car, and therefore we should have more money.
No, but I mean, again, the conduct here is not of that sort of order.
You say conduct plays a part of the assessment.
Yes, we do.
And so that you're saying here...
I mean, this is a father who is not going to
Can I just say that my reading in Chamberlain, I don't know if my Lord Justice Moylan's the same, is that provided that parents meet their responsibilities to their children as long as the children are dependent, I was thinking in terms of financial responsibilities, not that that was importing conduct.
Well, it's all the circumstances of the case. The position is here since January 2018. This father has not discharged apart from what he was forced to do in the order, has not discharged his responsibilities as a parent. That's
his non-financial.
His non-financial responsibilities since January 2018 onwards. And the court, going through the background, the court bent over backwards to see if a relationship could be resumed and required him to be assessed, and he declined. And so he isn't meeting his responsibilities. And what is quite interesting, of course, about Chamberlain is that the Lord Justice Scarman didn't necessarily rule out that the home would be preserved beyond education. If you look over the page 92, in a paragraph that begins, that leaves outstanding only one matter, where he says the trust for sale should be subject to an order. This house should not be sold for the time being. I'm satisfied it would be wrong to sell the house at any rate before the children have completed their full-time education. When that moment comes, there may well be a difference of interest. One cannot tell. It's possible at that time the wife will want to go on living in the house and providing a sort of family centre for her grown-up children and conceivably for their families. Very human wish. On the other hand, husband has an interest and he may want his money. And what actually the judge said, nobody at this date can say what would be the appropriate order in those circumstances. The order that I would propose in respect to the delaying of the sale of this house is that it shouldn't be sold until the children have completed their full-time education or thereafter without either the consent of the parties or the order of the court. So, although this has been alighted on as saying you must never make provision for adult children, that order contemplated that the adult children after education would not necessarily have to leave and the order and the house be sold unless there was an order of the court. And but what is important about this is that Mr. Justice Williams applied Chamberlain and the cases following it to the letter. There was no error of law. And we also say, so that's my second point about these children are doing no better than children of a marriage. There is power for children of a marriage to get an outright order, and so they're not doing any better. And they're also not getting more because we say, and I think my learned friend has misunderstood our point about this, is that in big money cases, making outright transfers to the children is unnecessary. In a big money case, the wife is going to get a sharing award and therefore the wherewithal to buy a first home. So it's quite unnecessary in this sort of cases like this to have a direct order. And if you hypothesize in this case a 21-year marriage, because this was a 21-year relationship, and she would have got an enormous award and would have provided for these children in their adulthood if the father did not. So we don't accept these children are in a better position, as my learned friend has said, than children of a marriage. And we also say where a wife was set up in a lap of luxury and her husband washed his hands and exercised coercive control, That might justify a divorce case judge departing from equality or transferring to the child. Issue 3 was the non-statutory guidelines, and I don't think there's really any issue between us about that. I mean, there's been no guidance at Court of Appeal level except Chamberlain, which has been followed in first instance Schedule 1 cases. The jurisprudence shows that the criteria are special and exceptional circumstances. Mr. Justice Mumby in Re N said that was likely to be the same, and Moylan friend showed you that passage, paragraph 68. It's quite clear that the power should be exercised sparingly. Well, Mr. Justice Williams followed that in paragraphs 85 and 161. It's also completely clear that the special circumstances are not limited to physical disability, handicap, and it's widely defined. And one can see that. Perhaps we should just look at Re N at which is at 150. And could I refer to paragraph 79? Where Mr. Justice Mumby follows the law about special circumstances and then makes this comment on the fourth line: absent such special circumstances as disability, no doubt widely defined for this purpose. So could certainly not just physical disability. And then to the same conclusion in MT and OT, which is at 103. Paragraph 87. This was a case in which Mr. Francis QC, as he then was, pursued a transfer of property order. But of course there wasn't any special circumstances relating to the children, vulnerability on everything, anything like that. And his conclusion at the end of paragraph 87 on 126, the powers, about 4 lines up, the powers in 1, 2D and E should only be exercised so as to confer an absolute interest on the relevant children in special circumstances. As will appear from the cases, the court has held those special circumstances are special circumstances relating to the children, which we say Mr. Justice Williams followed that, and not, for example, the extreme wealth of the father. Well, he didn't make the order because of that. They include, for example, whether a child suffers from a disability and matters such as that. So, and exactly the same conclusion comes in TBS, which is it starts at 189.
Sorry, can you give me the page again?
189 it starts at. The Lord, what I wanted to look at was um, 194. Mr. Justice Johnson, I recognise the penultimate paragraph. There may be circumstances in which it's necessary for the court to make provision for children based upon their having a continuing need after they've attained their majority, and indeed after they've left full-time education. And then over the page, the third paragraph, whilst I do not think the category of special circumstances should be necessarily always so limited, it does seem to me that its reference to special circumstances in relation to the duration of periodical payments, Parliament was intending the court ordinarily to look at special circumstances related to the children, such, for example, as some physical or other handicap. So, again, we say Mr. Justice Williams completely followed that, and it obviously is the case that the case law is not rigid, and one gets that from Rien, paragraph 69. Rien starts at 150. Paragraph 69. Is on page 166 of the authorities bundle, where Mr. Justice Mumby says in paragraph 68, Schedule 1 does not in terms preclude a settlement extending into adult years, and the case law is not rigid. And as I've indicated, it has to be related to the child, not the wealth of the father. He followed that, and that's MT and OT. And it's obviously possible that we would say that a dependency, because of special circumstances, may extend beyond full-time education. And that was envisaged by Mr. Justice Mumby in paragraph 79 of Rien. I've made the point about the father not discharging his parental
Yes,
responsibility.
you've dealt with that.
Yes, I dealt with that. And we say that all this guidance on the statutory interpretation was applied by Mr. Justice Williams. And his summary at paragraph 85 of his judgment, which I'm not obviously, because I've obviously read it, is impeccable. Power to make outright capital transfers exists, but will only be deployed in limited circumstances and where the evidence justifies it. It seems to me that what one is focusing on is the child, and when there's something about this child or this child's situation in particular that creates a situation which exceptionally generates a need for the child to be provided with capital. And he comes to that view having reviewed all the authorities from paragraph 72 onwards.
Now that clearly follows on. I think you've dealt with what in all of that is why you say the judge was not wrong.
Yes. And I then, I think I said it was issue 4.
Yes.
Issue 5, it was issue 4 that I've dealt with.
I think you've dealt.
To a great extent.
Yes.
But
And we've dealt with 5.
5 is conduct, I think, isn't it? Yes, I haven't dealt with conduct yet.
Well, now can we see where we are? Because it's obviously 4:15 now. I know you lost a few minutes of your half time, but we do need a reply also.
Yes. Well, perhaps I can deal with the rest in bullet points, and then I think I can, if I can have 10 minutes, that would.
How long are you going to need in reply?
I don't think very long at all.
Very long.
Obviously I've made the point on issue 4 that there is an unfettered statutory discretion. There's no caveats. It's fact specific, and the court has to consider all the circumstances, which Mr. Justice Williams did in a careful judgment. Special circumstances is not a closed category, and Mr. Justice Williams was steeped in the case, as I've said, and given that there must be special circumstances, we say it must follow that those special circumstances are such that will continue to have relevance during the child's adulthood is here. That must follow. So you are looking for special circumstances that go into adulthood, or only eventuate then, as in a disability, where the prognosis is deterioration as an adult. And we say that the judge was not plainly wrong, and I don't want to go, what we rarely say is that he came to a conclusion based on findings. And I know that the court has read the chronology, I know that you've read his findings. They are extremely serious findings. And what I rely on, in a nutshell, is the findings he made in paragraph 104 onwards, particularly paragraphs 104, 109, 114, 115 and 118.
Sorry, 104.
109, 114, 115 and 118.
Thank you.
And he based himself on the findings of the recorder, and that's clear from page 272. And unless the court wants me to, I'm not going to go through those findings.
We've read them and we'll
Yeah.
we will reread them.
Yeah. And we say not plainly wrong. I think I've dealt with the expert evidence point and what Mr. Justice
Yes, you have. Thank you.
said that, and of course we just say not necessary as required under Part 25. Reference to the report of Sturge and Glaser, well, that was prepared for the seminal case of Riel, which was the leading case on domestic violence, before the recent case of RHN. And that was a report prepared on behalf of the official solicitor, and it was approved in that case. Floodgates. Well, again, it's an exceptional case. And I do want to say something about paragraph 57 of my learned friend's submissions, because I just don't really... sorry, am I looking at the... where he says, if the decision below in the instant case is correct, the applicant in FS and RS, and that's the case that your ladyship referred to, you gave it a name, would at least in principle to be entitled to apply for an order if his parents had separated, even if that separation had taken place when he was 40 years of age. That cannot be right. It just doesn't follow, because at age 40 or whatever he was, he couldn't apply for a transfer of property, couldn't apply for a settlement of property. So it's got nothing to do with this case. Theoretically, I suppose he could apply under paragraph 2 if there were special circumstances, and why we didn't put it in the bund, that is what Mr. Justice Mumby said. So we say it's really got nothing to do with this case. And there isn't a floodgates aspect of this, because this is such an exceptional case. I think it's conduct that I need to deal with. It won't take me long. OVP number 2. Mr. Justice Baker, as he then was, took it into account. Yes, the conduct was extreme there, but it was all directed to the mother. So the conduct here was also directed to the children. And of course, the judge found that it had a profound effect on the life and lifestyle of both the mother and the child. There was one child there. And my learned friend says, well, this didn't lead Mr. Justice Baker to make a capital award. Well, he wasn't asked to make a capital award, so it doesn't help him. There was only 720,000 of capital in that case, and the mother took much of it as backdated periodical payments. So it's hardly surprising that there wasn't an application as is here. But it is accepted, it seems, that conduct can be taken into account as part of all the circumstances. But the prominence over the other paragraph 4 matters is illusory, because in deciding whether to make outright position, none of the paragraph 4 matters are particularly relevant except his resources, and they really didn't come into it because he took the millionaire's debate. Mr. Justice Williams did not make this order just because the father was wealthy. He made that clear in paragraph 85. And the windfall point, I think I've already dealt with there. My client did not seek this application, make this application, nor is she, as it were, responding to this appeal in order to get a windfall for herself. Indeed, she's doing it really on behalf of the children. My lady, I thank you for giving me that.
Not sure.
If there's anything else,
No, just do check. Well, thank you very much indeed. I'm very grateful. Yes, Mr. Baker.
Lady, very briefly, I hope. Just a couple of points. It was common ground, or it was something that my client offered, that he would pay lump sum for computers and iPhones and so on. Yes, it was. Completely pragmatic. The R could have applied for that. K was applying for it. this is not property adjustment. It is lump sum, smallish lump sum, certainly relatively speaking, for specific items. And my client, in principle, didn't object to that. He does object to being ordered to buy properties in 7 years' time. Matrimonial Courts Act versus Schedule 1 in terms of post-18 years old new application, or first application, as I think your Ladyship called it. I don't know that there's any authority as I sit here now, but certainly I've had to have this argument many, many moons ago in a county court where a district judge declined to hear a mother in person, I believe, who wanted to apply for, on her daughter's behalf, I think it was a daughter, for school fees. There is a difference. There having been a divorce suit, it's by virtue of a combination of the way that child is defined and the way that applications are permitted to come before the court. Section 23(1)(a) says, at any time after a divorce, after a decree, the court can make an order. And there's no limitation on that, except that the Section 28 and Section 29 limit duration and property transfer unless there's special circumstances or education. So because the order is available to the court at any time after decree, there has to be something to bring it to an end. Schedule 1 starts the other way around and says you can make an application for a child, or an adult can make his or her own application. You don't need anything to, as it were, row back the time within which that can be made. And so where the parties are divorced, where the parents are divorced, either of the parents can apply at any stage, or if neither of them does, which was Downing, the child can intervene and apply, in that case, herself. And so it's because of the different ways in which the definition of child are set out and the availability of relief works with that. As I say, I can't remember if since then, because it was a long time ago, there has been any authority. But assuming your Lordship is with me, and I think Mr. Howden and I agree on this, it might generally be worth dealing with that in any judgment. Entirely, obviously, a matter for you. Couple of points on the authorities. FS and RS is the case that your Lordship was thinking of earlier on. We didn't put it in the bundle from recollection because we were already up to about 15 cases, and Ms. Justin Mumby in the end decided that whatever else, the claimants or the applicant's parents were still living together.
Absolutely.
No claim. So it's anything else will be obiter, but we don't think, on a quick reading over lunch, that the point your Ladyship was referring to is dealt with therein. I mean, we'll have another look, but we don't think it is. Chamberlain, I just want to make one point, Mr. Howard still can't bring himself to read the whole of the proviso, provided that the parents meet their responsibilities to their children, as long as their children are dependent on them. And so it's a dependency on the parties that, father in reality, I suppose, in a Schedule 1 case, that father needs to comply with, and he does, and this father will, as the judge found. O and P, the behaviour that Moylan says was only directed against the mother. Here it was directed against the children. Lady, I have summarised in paragraph 45 of our skeleton on core 26 what had happened in O and P. Father had kidnapped the child, twice solicited hitmen to murder the mother, and been convicted on both offences, gone to jail for 19.5 years, for part of which he was still in jail. From jail, had delayed the case with, quote, various ploys and manoeuvres, and even then, as we make the point here, the conduct was relevant, not because he'd engaged in it and been sent to prison for most of the child's childhood, but because had he not done that, he would have been able to provide financially for the child. To suggest that this all had no effect on the child and was only behaviour which affected the mother is, we respectfully submit, nonsense.
Well, if you're looking at emotional abuse, the father being convicted for attempting to murder your mother and then arranging a second hit from prison, which, as I understand it, is what happened.
Yes.
It's going to be pretty emotionally difficult.
You'd have thought it would be quite high on the scale. Lady, in terms of the evidence, Mr. Howard says the father was cross-examined about manipulation and control. One of the beauties and burdens, but one of the advantages in this case of an e-bundle is that you could search for words. I did a quick search whilst my learned friend was making submissions for the word manipulate in the father's evidence. It was used only by the father, not by Mr. Howard, mostly in relation to what he said the mother was doing, and by Mr. Howard once when he repeated an answer back to the father. And control was used only in relation to the visa funds, not in relation to other financial control, and by the father when he said he didn't have control of his temper. It wasn't otherwise mentioned. Supplemental bundle C100. My own friend took you to C99, and I think it was your ladyship, or it may have been Lord Justice Newey said, well, this is the sort of view of any father might express. And then my friend took you to the bottom, and my client was telling the judge, started working when I was 20, moved to a different city, and so on. And then over the page, I don't think you did get to, and I would just ask you to read C100 down to G. If you did get that far, I'm not sure, but I'm not sure you did. If you did, then I apologise, but these, we say, are perfectly sensible and reasonable approaches. Two final points. When the learned judge raised with me in submissions, it's C126 in the core bundle. Oh, no, it's not. It's in the supplemental bundle. Given that it is C126 supplemental bundle. As Howard said, he put a financial ultimatums fairly and squarely to me. We respectfully disagree and submit he did nothing of the sort. See, at the top, when they reach the end of minority, there is going to be potentially a vulnerability. And I say upon whom, I took you to this part already. Children, and I said they won't be children of their parents. And I said yes, and then he said that will leave them vulnerable to the financial muscle the father is able to deploy. And so I said, well, I'm going to take you to some authorities involving a lot more financial muscle. And then at F, I say he, that is the father in A&A, had substantially more financial muscle than my client. The child would have spent the entirety of his life effectively, and the judge says that's not what I'm referring to. And he says, appreciate in any case like this, ability of paying party to create a lifestyle which cannot be replicated after a minority or education is one which will be present in most cases. But I think potentially in this case there's a difference. perhaps there's authority on it, there are grave findings of domestic abuse against the children themselves may create a need in them which is different to that for children who have not been exposed to that abuse. That is not a threat from financial ultimatum from father. And I say, well, I'm going to submit there's no evidence that they have such a need, no evidence they need this property. So as I said earlier, I seem to still be thinking of referring to the London property. It might mean one less move. And then he says in relation to to K, at C, I say your lordship would be providing for her when she is an adult, and it would simply be sidestepping the limitation of the Act. But if you can do it for a child who is under a disability, why not for a child who is under vulnerability? And I say special circumstances. So at no point in my submission does he even then put to me any form of ultimatum, and frankly, even in his judgment, he doesn't suggest with any specificity what it might be. He says an ultimatum of some sort or another, I think is the precise phrase. Well, the lady just raised the difficulties with the difference between that and fantasy. With the other friend, I don't want to repeat that. The other friend, I think, more or less concluded with what you need to do is marry up the manipulation to the ability to do something about it. We submit that comes dangerously close to two things. One, punishment. And two, one law for the children of wealthy fathers, one for the children of less wealthy fathers. Point's obvious. But unless there's anything else, I think that's all I would say.
Lady, could I just clarify one point, because I think my learned friend misunderstood what I was having to say about Chamberlain. I didn't ignore what he said. What I said was that this father was not meeting his parental responsibilities from 2018 onwards. I wasn't talking about relating to that to 23 or 27 is what I said. So I did not ignore it.
Thank you. No further questions. Very well. Thank you both very much. It won't surprise you that we're going to reserve our judgments. This case obviously is of considerable importance to the parties in the case, but it's obviously got wider implications as well, given the importance of the Schedule 1 proceedings, which are becoming more common, not less, I think, is all our joint experience. Can't give you an exact date when we'll be handing down the judgment. Obviously, it depends on how things go and pressure of other work, but of course it will be done as soon as is practical. It'll be sent out in the normal way for typographical and minor grammatical errors, not as an invitation to re-argue the matter. We'd hope we'd be able to deal with any other consequential matters in writing, and that ultimately you'll be able to agree an order as between you. Hand down, I think, will still be electronic in the light of the COVID regulations, but in any event, in the unlikely event that we're back to hand downs in court, it won't be necessary for any of you to attend.
Thank you.
Can I thank you, not just both of you, but those sitting behind you, your juniors, who've clearly worked very hard on this matter, and of course the legal teams who are in cyberspace that I can't see.
My lady, I'm assuming, because you don't want you did canvass more help on the MCA section 23(1)A and 29 point, but it seems that my learned friend and I are agreed on that.
It looks like it.
That there is.
Do you need it? Do you need it? No, well, thank you very much. Well
just
done
want
for
to leave that
remembering
up.
that. No, thank you for reminding me, Mr. Howard. No,
it seems that we are in agreement that there is jurisdiction at any time.
It sounds like it.
With the section 29 limit.
Yes. Very well. Thank you all very much indeed. I should say I apologise again to everyone that was on the wrong end of the live streaming this morning.